So, good afternoon, class. It's been a while since we had our class, but hopefully, we will be able to have our regular classes soon. So, as promised, there will be instances where we will have to extend our discussions to make up for the lost hours. Because of my hospitalization. So, I'm already back home for everyone's information, but I still do have to have some follow-up checkups with my doctor, but hopefully I'll be able to fully recover very, very soon, God willing. So anyway, the last topic that we had was, of course, on I think it was on exempting, justifying circumstances, exempting circumstances, and mitigating circumstances. So we are already done with that. Now we move on to the aggravating circumstances. So what are aggravating circumstances? So aggravating circumstances, these are actually circumstances that affect criminal liability and could actually increase the penalty for the crime. So later, after we discuss the different types of aggravating circumstances, we will find out what is the effect. If there is one aggravating circumstance, or if there are two or more aggravating circumstances present in the commission of the crime. So let's begin our discussion. I will now share my presentation. Okay, so we are now on Article 14 of the revised penal code. So actually we are nearing the end on the most important topics on the revised penal code. So the next topics would focus more on the penalties where we can actually just summarize them. Now, but for now, let's first discuss the aggravating circumstances and also to emphasize what is the effect if there are aggravating circumstances present in the commission of the crime. So under the revised penal code, there are 21 aggravating circumstances available. Okay, so let's begin our discussion. So, Article 14, aggravating circumstances, paragraph 1, the first aggravating circumstance is that advantage be taken by the offender of his public position. So, for example, in the case of US versus Torrida, the accused, shortly after entering upon his duties as councillor of the town, ordered that deaths of all large animals must be reported to him as councilman. As a result of this instruction, the owners of several such animals were induced to pay the accused supposed fines on the belief that such were required by a municipal ordinance. He spent the money paid to him and received by him as fine. So imagine, no, there was no ordinance. Suddenly, this councilor of the town ordered everyone to to report all death of large animals such as carabaos, pigs, and because of that, um, people who owned these dead animals actually believed that they had to pay the fines. So here, the said councilor spent the money he received that was supposedly a fine for his own consumption. So imagine, no? So it's a form of graft and corruption. So what was the decision of the court held? The fact that the accused was a counselor, so he is a public officer, at the time placed him in a position to commit these crimes because if he were not um a counselor, he could not have induced the injured parties to pay these alleged fines. It was on account of his being a counselor that the parties believed that he had the right to collect the fines. So imagine, they were all induced to pay the fines, to collect the right to collect the fines, and it was for this reason that they made the payment. So take note, there was no law mandating payment of fines for death of large animals. But then suddenly this counselor just decided to exact some fines, which is also not allowed under our laws, because if there are certain penalties, it should be a local ordinance and national law. So it is likewise true that he had no right to either impose or collect any fine whatsoever, and it is likewise true that a municipal councilor is not an official designated by law to collect public fines. But these facts do not destroy or disprove the important fact that the accused did, by taking advantage of his public position, deceived and defrauded the injured parties out of the money they paid to him. And what made it worse is that he actually spent the money, the fines, allegedly fines, for his own consumption. Okay, so that's taking advantage of his public position. So that's one aggravating circumstance. Now let's go to the second one, that the crime be committed in contempt of or with insult to the public authorities. For example, A and B are quarreling on a street, and the municipal mayor, upon passing by, attempts to separate them to stop the quarrel. Notwithstanding the intervention of the presence of the mayor, A and B continued to quarrel until A succeeds in killing B. In this case, A commits the crime of homicide with aggravating circumstance of a contempt of or with insult to the public authority. So imagine the mayor, the executive of the town, was already there stopping them from their quarrel. But then, despite that, they still continue to fight. And at the end of the day, homicide was committed. So there was actually obvious insult to public authority. So a mayor is actually a person in authority. So he should be regarded with much respect. No, and the commission of a crime in his presence is could actually lead to an aggravating circumstance for such crime. Okay? Now let's go to paragraph 3. That the act be committed with insult or disregard of the respect due to the offended party on account of his rank, age, or sex, or that it be committed in the dwelling of the offended party if the latter has not given provocation. So imagine there are four of how many? Yes, four. Number one, obvious disregard of his rank, age, or sex. Or, and number two is that the crime committed is in the dwelling place of the victim. Okay, so it's an aggravating circumstance. So, if theft is committed inside the dwelling place, where dwelling place hainhira na ukoy. So, if it's committed inside the dwelling place of the offended party, then there's one aggravating circumstance of commission of a crime in a dwelling place. No, so for example, killing a judge because he was strict or because of resentment, which the accused harbored against him as a judge, constitutes the aggravating circumstance of disregard of the respect due to the offended party on account of his rank. So take note, a judge should also be treated with much respect. No, a judge yeah, is a high-ranking figure in the Philippine government. So he should always be treated with utmost respect, even in his private life. No, so here the killing of the judge can actually have one aggravating circumstance, with insult or disregard of the respect due to the offended party on account of his rank. Okay, so for example, likewise, a student slapping the face of his or her teacher, that's already an aggravating. There's also an aggravating circumstance there on account of rank, age. No, so that would be slander with an aggravating circumstance of obvious disregard of his rank or age. So with the same with a judge. Okay. But if it is the teacher who slaps the student, there is no aggravating circumstance on account of rank, age, or sex, because naturally a teacher would be higher in rank, age, or age. No, so but if it's the other way, if it is the student who actually slap the teacher, then there's an aggravating circumstance on that under paragraph 3 of Article 14 of the Revised Penal Code. Next, that the act be committed with abuse of confidence or obvious ungratefulness. Requisites: that the offended party had trusted the offender. Number two, that the offender abused such trust by committing a crime against the offended party. Okay. And number three, that the abuse of confidence facilitated the commission of the crime. No, so there was a domestic helper, correct? Sigmund, pabulig, no, in the house. So naturally, if that domestic helper has already been with the family, with the household for several years, the employers would trust that domestic helper. If that domestic helper commits theft and steals the property of his or her employer, then he could be held liable for qualified theft, not just simple theft. Okay, it's going to be qualified theft because there is an aggravating circumstance under paragraph 4 that the act be committed with abuse of confidence because the employer trusted the domestic helper. But nonetheless, despite such trust reposed upon him or her, he or she still decided to commit the crime. So the first requisite is present there, that the offended party had trusted the offender. Number two, that the offender abused such trust. So the offender actually used such trust to gain access to such properties. And then such a trust actually facilitated the commission of the crime. So that's why if a domestic helper commits theft against the employer, it's not just simple theft. It is actually qualified theft because of the aggravating circumstance under paragraph 4. So don't forget about that. Okay? Now let's go to paragraph 5, that the crime be committed in the palace of the executive, our president, or in his presence, or where public authorities are engaged in the discharge of their duties, or in a place dedicated for religious worship. So the chief executive or our president need not be in the palace. His presence alone in any place where the crime is committed is enough to constitute the aggravating circumstance. This aggravating circumstance is present even if he is not engaged in the discharge of his duties in the place where the crime is committed. So likewise, for example, I don't know if you've heard about this. There was one influencer before. He dressed up as I think Padre Damaso and entered a church in Manila. So um he was charged for unjust vexation with an aggravating circumstance, no, uh for the crime being committed in a place dedicated for religious worship. So kamo kita diri kita pwede magpinasaway sa simbahan or sa simbahan and other religious denominations because these places are actually protected by our laws. So you should not commit a crime. So if there's theft inside a church, then that's an again qualified theft. Kay may the aggravating circumstance for the crime being committed in a place dedicated for religious worship. Also, if a crime is committed in a government office, so we cannot also do that. Dili kita pwede mag-run amok. Dili pwede kita magwala basta-basta ang mga government offices, especially if the employees and officers or public authorities in these public offices are actually in the discharge of their official functions. Because if a crime is committed, such as unjust vexation, kung nakadamage dahil property, malicious mischief, then there's an aggravating circumstance on that. And the penalty could be higher. Okay, number 6, that the crime be committed in the nighttime, gabi, or in an uninhabited place by a band whenever such circumstance may facilitate the commission of the offense. Example, with the finding of the body of the victim in a solitary place off the road and hidden among the trees and tall grasses on a hill, some 500 meters away from the toll gate where help to the victim was difficult and the escape of the accused seemed easy, it is correct to appreciate the aggravating circumstance of an inhabited place. So, ito, that's why if for example, may the mga ginrape and ditira mga kabagwakan ginrape, no, there's also an aggravating circumstance on that of an inhabited place. So again, the penalty could be higher for that because of the presence of the aggravating circumstance. Number 7, that the crime be committed on the occasion of conflagration, shipwreck, earthquake, epidemic, or other calamity or misfortune. Ini na. Example, an example of this circumstance is the case of a fireman who commits robbery in a burned house, or that of a thief who immediately after a destructive typhoon steals personal property from the demolished houses. So if you can still remember tomorrow, Yolanda anniversary or commemoration of the Yolanda typhoon. No, so if you can still remember, many people ransacked the department stores and Robinsons, no? So many of them took the properties such as television sets. I don't even know why people did that, because at that time there was no electricity, so there was really no need for those types of appliances. But yun, those people could have been charged. I'm not sure what happened because actually Robinsons has some footages on that. So those people could have been charged for qualified theft. But siguro, for humanitarian consideration, they decided not to pursue that. But honestly, if those people were charged with theft, it would have been qualified, and the aggravating circumstance under paragraph 7 could apply because the crime was committed on the occasion of conflagration, shipwreck, earthquake, epidemic, or other calamity or misfortune. So that time it was a typhoon. So it was a calamity. Okay, but again, I'm not sure why Robinsons decided not to pursue that, but then again, yes, it's still a crime. Ada na lang ito kung may magfa-file, 'di ba? So, also if panluluting after hiton sunog, that's also punishable under the law. So, ayaw kita ito. Do not engage in such acts because even if no one is filing the cases, it's still punishable under the law. And the presence there's even the presence of an aggravating circumstance, and again, it could result to higher penalties, no? Okay. Paragraph 8, that the crime be committed with the aid of one armed man or two persons who ensure or afford impunity. So there are two ways. Number 1, may ada usa nga armed men, may ada hiya weapon. Or kung waray man weapon, duha nga tawo. So for example, A, in order to get rid of her husband, secured the services of other Moros by promising them rewards and had them kill her husband. In accordance with the plan, they armed themselves with clubs, went to the house of the victim, and clubbed him to death while A held a lighted lamp. A also supplied them with rope with which to tie her husband. In this case, A committed parricide with the aid of armed men. So, what are the requisites? Number one is either bisan usa lang nga tawo ang nagbulig basta armed, may adahiya weapon, or kung waray man weapons, duha nga tawo ang nagbulig para makommit an crime. Okay? Paragraph 9. That the accused is a recidivist. This one, it's more on repetition on the commission of crimes. Who is a recidivist? A recidivist is one who, at the time of his trial for one crime, shall have been previously convicted by final judgment of another crime embraced in the same title or revised penal code. So, for example, this person has already been convicted. Final na ang iya case, no, with finality na he was already serving his sentence. Let's just say he was convicted for physical injuries. And then, while in prison, he committed another crime with his co-prisoner, again for physical injuries. So he is now considered as a recidivist. So that's going to be an aggravating circumstance on the second case. No? So what are the requisites for recidivism? That the offender is on trial for an offense. So may dinalawat bago nga trial. That he was previously convicted by final judgment of another crime. So there are two trials, and first trial tapos na, convicted na siya, and now he is also again under another trial, and that both the first and second offenses are embraced in the same title. So what do we mean when embraced under the same title? So our revised penal code actually is divided into several titles, no? So, in Book 2, Title 1, Crimes Against National Security and the Law of Nations. Title 2, Crimes Against the Fundamental Law of the Land or the State. Title 3, Crimes Against Public Order. Title 4, Crimes Against Public Interest. Title 5, Crimes Relative to Opium and Other Prohibited Drugs. But this one is already under Republic Act 9165 or the Dangerous Drugs Act. Repealed na ini nga Title 5. Title 6, Crimes Against Public Morals. So, may mga gambling, betting, offenses against decency. Title 7, Crimes Committed by Public Officers. So, may mga sinisiring nga malversation, graft and corruption. Title 8, Crimes Against person. So, amo na din yan mga sinisiri nga mga physical injuries, parricide, murder, homicide, infanticide, abortion, duel, destruction to life, crimes against personal liberty and security, Title 10, crimes against property, Title 11, crimes against chastity. So, amo ito sinisiri nga mga titles under under the revised penal code, under that title, may the mga specific crimes. So, for example, if it was physical injuries, it is again under crimes against persons. So, here, to be held liable for recidivism, kung physical injuries man na niya first offense, dapat ang second offense are still those defined under crimes against persons. Okay? Or Title 8 of the Revised Penal Code. So, and lastly, that the offender is convicted of the new offense. So, convicted liwat hiya second offense. So, that's why, even if physical injuries, they both essentially would have the same penalties, but because there's recidivism on the second crime, then the penalty could be higher than that of the first conviction. Okay? Paragraph 10, that the offender has been previously punished for an offense to which the law attaches an equal or greater penalty, or for two or more crimes to which it attaches a lighter penalty. So this one naman, it doesn't necessarily have to be embraced in the same title. So anywhere in the revised penal code. So this is reiteration. No, the first one is recidivism, the second one is reiteration. So if the offender has already been previously punished, so convicted na hiya for an offense to which the law attaches an equal or greater penalty, or for two or more crimes to which it attaches lighter penalty. So for example, no, he was convicted for less serious physical injuries. And then the second one, he was convicted for theft. No, so that's where the aggravating circumstance under paragraph 10 enters. So the requisites would be that the accused is on trial for an offense. So there are two offenses or three offenses that he previously served sentence. So tapos na hiya. Nakalaya na hiya for another offense to which the law attaches an equal or greater penalty of two or more crimes, which it attaches penalty than that for the new offense. Okay, and that he is convicted of the new offense. So duha, ikaduha na niya nga pagkuan. Ikaduha na niya nga pag-commithan crime. So, ito, ayaw pag diri kita magpipinasaway, diri kita mag-utro-utro pag-committing crime, because the more crimes that we commit, then the higher the penalty becomes. No, because repetition or commission of crimes is not of course not of course sanctioned or not being promoted by the law. So ginpapahigher ang penalty so that people would be discouraged from committing crimes. Okay? So there are also other ways to which a higher penalty could be imposed, especially if there's habitual delinquency. There is habitual delinquency when a person within a period of 10 years from the date of his release or last conviction. So, na-convict na hiya, nakalaya na hiya, but then, uh, nakalaya ya for the crime of specific line niya ha, physical injuries, robbery, theft, estafa, and falsification, is found guilty of any of said crimes a third time or oftener. So katulo na niya ginhimo, no? In habitual delinquency, the offender is either a recidivist or one who has been previously punished for two or more offenses. He shall suffer an additional penalty for being a habitual delinquent. Okay, so there's another a higher penalty for that. And also quasi-recidivism. Any person who shall commit a felony after having been convicted by final judgment before beginning to serve such sentence, or which serving the same shall be punished by the maximum period of the penalty prescribed by the law, or new felony. No, defendant while serving sentence is in bilibid for one crime struck and stabbed. Sample niya, the foreman of the brigade of prisoners. Under Article 160 of this code, he shall be punished with the maximum period of penalty prescribed by the law for the new felony. No, so mas taas talaga ang penalties. Mas nagtitikada mo ang crimes ka nakukomit, mas nagtitika taas ang penalty. Okay? Next, paragraph 11, that the crime be committed in consideration of a prize, reward, or promise. So, ginsuhulan. So, P procured an ignorant man to kill the brother. And P for a reward of 60 pesos. So, may ginsuhulan. The ignorant man, following the instructions of P, killed them. Held. Murder by inducement of a price is committed. So, ini because may gimpatay na diri na yung homicide. Because of the aggravating circumstance, it now becomes murder. So, homicide, di ba? It's only reclusion temporal, which is from 12 years to 20 years, mahataas na hiya, mahihimo na hiya nga 20 years to 40 years of imprisonment because it's no murder, no, and murder is grave crime, no, and it's punishable by afflictive penalty such as reclusion perpetua. Okay, that the crime be committed by means of inundation, fire, poison, explosion, stranding of a vessel, or intentional damage thereto, derailment of a locomotive, or by the use of any artifice involving great waste and ruin. So, yun, by means of fire. So, kung para makapatay kita, ginsunog naton ang balay, no? Ang tao nga gusto naton patayon, then that is also already murder, no? Because of the aggravating circumstances by means of fire. Kung ginlabugan naton hing granada, didto para mamatay itong nga tao. So by means of explosion, this already also murder and is punishable by reclusion perpetua and by means of derailment of locomotive. So ginkuan naton an sarakyan, no, ginguba or ginpastrand. So yun. These are actually aggravating circumstances which will now elevate the crime and will increase the penalty. Okay, next slide. Paragraph 13, that the act be committed with evident premeditation. So, ginpagplanuhan. So, US versus Manalinde. Facts. The accused who pleaded guilty confessed that his wife died about 100 days before, that he was directed by Dato Mupok to go Harumantado and to kill the two persons he would meet in the town. Harumantado magwala, diba? That if he was successful in the matter, Mupok would give him a pretty woman in his return. That in order to carry out his intention to kill two persons in the town of Cotabato, he provided himself with a kris, which he concealed in banana leaves, that he traveled for a day and a night from his home, that upon reaching the town he attacked from behind a Spaniard, and immediately after he attacked a man who was close by, and that he had no quarrel with the assaulted. So those facts established the aggravating circumstance of evident premeditation. Kay mamay, pero pa nga niya kaadlaw nag-travel, no, para lang makomit niya crime. So this is actually an aggravating circumstance because yun, even if kaging pagplanuhan talaga niya, no? Yung pagplanuhan talaga niya ang pagpatay, no? So, karag sigon, there was really intent to commit the crime. So that's why this also becomes murder. Okay? Next, paragraph 14. That craft, fraud, or disguise be employed. Craft, the act of the accused in pretending to be a bona fide passenger in the taxi cab driven by the deceased, when they were not so, in fact, in order not to arouse his suspicion, and then killing him, constituted craft. So, ginuwat, no, ginuwat. So, ginpalabas nira nga passenger hira, yun pala, hold-upper. So, ito, di ba, very uso ito, especially in metropolitan areas wherein some criminals would pretend to be passengers, normal passengers, and then would proceed to killing the driver. No, so ito hiya, it's not just simple homicide, it's already murder. No, okay, because of the employment or the use of craft, fraud, or disguise. Okay? So we are almost done. We have 21 paragraphs. Paragraph 15, that the advantage be taken of superior strength or means be employed to weaken the defense. For example, an illustration of the cases which fall within this provision is where, for example, a strong man has ill-treated a child. No? So, dakon lawas, Maltreat niya ang child, an old or decrepit person, or one weakened by disease, or where a person's physical strength has been overcome by the use of drugs or intoxicants. In each of these cases, there is a marked difference of physical strength between the offended party and the offender. So that's why ito nga ni nga mga spike it mga drinks para maka-rape, no? Ginbubutangan mga party drugs para makapan-rape. That's also qualified rape. It's not just simple rape. And there's an aggravating circumstance of taking advantage of superior strength or the employment of or means employed to weaken the defense. Kaya syempre, pagbutang ito nga mga drugs, ma-weaken man ang sistemhan babayi, o wadi rin na hiya makakasagang han mga advances sa iyahan rapist. So that's why this is also punished under our laws. So please take note of that. Spiking of drinks is not it's not sanction it's punishable by law. So kamo ha pag mag-iirigdom nga ni kamo ayaw ninyo pag pinambutangihin kung ano-ano at iyong mga giniinom, especially kung ano iyong ginpapainom is dirihira maaram nga may ginbutang kamo. So not only because drugs or party drugs are prohibited, but also because it could become an aggravating circumstance for a crime. Okay? Next. Ano kita? Paragraph 16, that the act be committed with treachery or alevosya. There is treachery when the offender commits any of the crimes against the person, employing means, methods, or forms in the execution thereof, which tend to directly and specially to ensure its execution without risk to himself arising from the defense which the offended party might make. No? So example, where one assaulted another from behind but failed to kill the latter because the wound inflicted was not sufficient to cause the attack, was characterized by treachery even if the offender did not attain his end. So normally, for example, when a person is stabbed in the back, normally, itong case of ginfa-file hito, it's either frustrated, attempted, or murder. No, not just simple homicide, because there's already treachery, especially kung halikod talaga, no? Normally, amit at ginfa-file ng mga cases. So, actually, while I was in the hospital, there was also a patient there who got stabbed in the back by his own friend kay nagka-delito hera no warera magkaintindihay, suddenly he got stabbed in the back. So the case that was filed, he did not die, of course, because medical attention was immediately given, but then the case filed was frustrated murder. So still remember, no, frustrated stage wherein all of the elements necessary to commit the crime has already been executed, ginbuno na hiya. But then he did not die because of medical attention, no? So the crime was still not committed by reason independent of the will of the perpetrator. So that's why it was considered as frustrated murder. So magfa-file at frustrated murder nga case against her iya friend. So kamo, ayaw ko pag inaragway. So especially among men nga medyo mainit at ulo, ayaw ka mapagpadara ito because at the end of the day, the repercussions really are immeasurable. So imagine frustrated murder. Even if it's still frustrated, the minimum penalty is still at 20 years. No, 20 years of imprisonment. So imagine you'll be spending 20 years in prison. So as much as you can, please stay away from any altercation or yun, avoid any confrontation. Because again, the repercussion, the results of any crime is immeasurable. It's very difficult. It's very difficult to foresee what will happen to that person, to his family. No, because that person will be sent to prison. 1 year pa nga lahat prisuhan, makuri na. Imagine how much more kung 20 years, diba? So, just always take think about your family, think about the people that love you, think about the people that will suffer because of these types of crimes. So do not engage yourself in such activities. Okay? Paragraph 17. That means be employed or circumstances brought about which add ignominy to the natural effect of the act. So what is ignominy? Ignominy is a circumstance pertaining to the moral order which adds disgrace and obliquy to the material injury caused by the crime. So, ito nga ni nga gintatagan hinda kung nga kaarawdan ang victim. Example, it would be present in a case where one rapes a married woman in the presence of her husband. So, kung ginrape ang babae, hatubangan ng iya asawa, that's already qualified rape. That's not just simple rape because ignominy is present. Or alleged husband, bisan diri iya asawa. Basta, uh, there is reasonable belief nga asawa niya, or where the accused rapes a woman in the presence of her betrothed nga ni fiancé, karaslon na hira. Or where a woman was successively raped by 4 men. Imagine, you were raped by several men. Or where one of the victims was raped in the presence of her husband and the other successively raped by 5 men. Or where the accused used not only the missionary position, male superior, female inferior, but also the dog style of sexual intercourse, entry from behind. So imagine, no? Even the positioning during the commission of the rape is also taken into consideration. So may nagihapon nito. There was a case actually wherein may the babae, she got raped, and after raping her, no, the man decided to pour melted candle wax on her breasts, and then ang candle ginsulod didtohan iya sex organ. So it was considered actually qualified rape. And again, qualified rape is also punishable by reclusion perpetua. No. So yun. So when you go to book 2 of the revised penal code, you will understand that there are several types of rape, not just with the insertion of the penis in the vagina, but there are other types of rape. So we will discuss that hopefully next year when we go back for the second semester. Okay. Paragraph 18, that the crime be committed after an unlawful entry. This is very technical, very peculiar. Example, the act of entering through the window, which is not the proper place for the entrance into the house, constitute a lawful entry. No? So imagine, gumamit kahin, bintana pagsulod, balay. That's already an aggravating circumstance, no? Even the entrance in itself, kay diri man bintana, diri man hiya dapat susudlan, 'di ba? Diri man tiya aragian. So by using the window to enter the dwelling place, it could already be considered as an aggravating circumstance, and could result in the increase okay, it could result in the increase of of the penalties that the uh, offender can suffer. Okay. Paragraph 19, that as a means to the commission of a crime, a wall, roof, floor, door, or window be broken. No, so iniliwat, for example, A broke a window to enable himself to reach a purse with money or that on the table near the window, which he took while his body was outside of the building. So, adi, wala man gubaan bintana. No, intact ang bintana. It's just that didto hiya umagi pagsulod na balay for paragraph 18. But for paragraph 19, purposely, may naging guba to enter, no, or to facilitate the crime. The crime of the theft was attended by aggravating circumstance. Note that because of the phrase as a means for the commission of the crime, it is not necessary that the offender should have entered the building. So here, it is necessary in paragraph 18, it is necessary that the offender entered the building. But here it's not necessary. It's just that the breaking of a part of the building was necessary for the commission of the crime. What aggravates the liability of the offender is the breaking of a part of the building as a means to the commission of the crime. So didi waray ginguba naggamit lahiya hinway nga diri man normally dapat ginaagian such as the window. This in here naman purposely may ginguba, no, wall, roof, floor, door, or window. But this one, it's not necessary that he or she entered the building. What is necessary is na may ginguba to facilitate the commission of the crime. Okay. Paragraph 20, that the crime he committed with the aid of persons under 15 years of age or by means of motor vehicles, airships, or other similar means. So number one, with the aid of persons under 15 years of age, A caused B, a boy 14 years old, to climb the wall of the house of C to enter the same through its window. And once inside, to take as in fact, B took clothes and other personal property in the house of uh, C. Then B threw them to the ground where A picked them up. The aggravating circumstance that the crime was committed with the aid of a person under 15 years of age should be taken into account against A. But take note, B, who is 14 years old, is exempt from criminal liability. Going back to our exempting circumstance, ha, because those ang pwede lang maging liable na below 18 are those above 15 and who have acted in discernment. But here, B is still 14 years old, so he is exempt from criminal liability. But A could be held liable for qualified theft for with an aggravating circumstance of um, with the aid of persons under 15 years of age. By means of motor vehicles, use of motor vehicles is aggravating where the accused used the motor vehicle in going to the place of the crime, in carrying away the effects thereof, and in facilitating their escape. Yun. So, kung may escape vehicle, that's also an aggravating circumstance. And lastly, no, we are already in paragraph 21, that the wrong done in the commission of the crime be deliberately augmented by causing other wrong not necessary for its commission. No, so after hog tying the victim, so can you imagine hog tying? Bagan ginhigot siya nga bagan baboy. No, the accused extracted the victim's left eye. So gintanggal niya ang left eye from its socket with a pointed end of his cane, and also stuffed the victim's mouth with mud. Imagine the cruelty that the victim had to suffer from the offender. So this is also an aggravated circumstance. No, so that's it. We have 21 aggravating circumstances under the revised penal code. So again, what is the effect of aggravating circumstances? So naturally, they would increase the penalty or the imposable penalty for the crime. No, so sometimes they also what? They also increase the crime from homicide to murder. No, so those are the things that we also have to understand. So please do not forget them. No, jemaah. Our keyword here is jemaah. No, please do not forget that jemaah is J is what? Justifying. E is exempting. M is mitigating. A is aggravating, and the last A, which we will discuss next meeting, is alternative circumstances. So do not forget all these things because these are all very, very important. And I want you to be able to always remember them, because honestly, when it comes to the law, repetition is always very important. So that's it for today. I think We've already discussed the aggravating circumstances thoroughly. Next meeting, we will be discussing the alternative circumstances, and we will be moving on to the next chapter, which will focus more on chapter 2. Sorry, no, not chapter 2. Title 3. Sorry. Title 2 pala, persons criminally liable for felony. So please prepare for next meeting. We will be discussing alternative circumstances. Article 16, who are criminally liable. Articles 17, 18, 19, 20. We will also be uh, discussing articles 21, 22, 23, 24, 25, 26 until 26. So we will be discussing a lot so that we can maximize our time. And of course, we will have a recitation for next week based on our aggravating circumstances. Okay, so we will meet definitely next meeting on Wednesday. I hope everyone will be available. We will be checking the attendance, of course. So please be present and I will see you then. So for today, I will be sending our attendance by around 6 p.m. So take note, we will have a short quiz, a very short quiz. So I hope you will be able to answer the questions. Again, do not forget when it comes to circumstances affecting criminal liability, jemaah. Okay, jemaah. Wait, I was jemaah. Okay, so what is jemaah? J. Okay, wait. So please do not forget this one because these are all very important. Jemaah. What is jemaah? Jemaah is J is for justifying, E is for exempting, M is for mitigating, aggravating, and alternative circumstances. So please do not ever forget this. These are all the circumstances affecting criminal liability. So this will definitely appear in our quiz this afternoon. So please answer the quiz because that will be your attendance for today's discussion. So thank you so much everyone for listening. I hope you listened until the very end. So hopefully you understood all the concepts under aggravating circumstances, and I'll just see you again on Wednesday. We will conduct the class, actual class, not just a recorded class. So anyway, please eat your lunch. I hope everyone are well and healthy. So God bless to everyone, and I'll see you again on Wednesday. So good afternoon, everyone. This is Attorney Mitch, and God bless. Bye for now.